it is illegal to engage in race-based gerrymandering. It's clear that the Alabama legislature engaged in race-based gerrymandering. We can at least draw some comfort from the fact that the 1965 Voting Rights Act remains alive.
That was Hakeem Jeffries, the top Democrat in the U.S. House of Representatives, speaking about a major Supreme Court ruling on Thursday. In a surprise 5-4 decision, the court ruled that the state of Alabama had, in fact, violated the 1965 Voting Rights Act with the way that its Republican lawmakers drew the current map for federal elections. Now, Alabama has 7 congressional districts. Currently, only one of them has a majority black population. That's the one in dark blue in the center left of the map you can see there. Now, that is even though black people make up 27%, so over a quarter of Alabama's total population. The Supreme Court ruling requires Alabama to now draw a second district with a black majority. This decision reaffirms the landmark Voting Rights Act signed by President Lyndon Johnson in 1965, which was designed to prevent racial discrimination in voting. The law came in response to black people being denied their rights to vote in Alabama and other southern states, precisely. That discrimination triggered peaceful protests that were often broken up brutally by police. Gloria Jane Brown Marshall is a professor of constitutional law at John Jay College in New York City, and she's also the author of the book, The Voting Rights War, the NAACP and the Ongoing Struggle for Justice. Ms. Brown Marshall, welcome back to DW. Good to see you. Give us a sense of how important this Supreme Court ruling is.
I think it's important not just because the U.S. Supreme Court has stood up to support the Voting Rights Act and continue the protections for people of color, not just African Americans, but Native Americans, Latinos, Asian Americans, but also because this was a chance, I think, that the conservatives were taking, hoping that the supermajority of the 6 conservatives would then decide to undermine or find unconstitutional the Voting Rights Act altogether. So people were holding their breaths thinking that the conservatives were going to come together and try to rid this country of these voting rights protections with this case. The case was weak, but there have been other weak cases that have come before the court. And the conservatives on the courts have bound together. And when they bind together in this way, it doesn't matter that what they're doing is not what the law should say that they do. They're doing it for political reasons. And it was thought that this was going to be one of those situations.
Yeah. How surprised were you by the decision, especially with Chief Justice Roberts' role? He's long worked towards weakening the Voting Rights Act.
He has. That was his specialty. And it was his doing with the Shelby County versus Holder case in 2013 that gutted a vital part of the Voting Rights Act. And I want you to understand this. This is a victory in a way only because they didn't do what they were not supposed to do. And everyone thought, well, they're going to use this opportunity to gut the Voting Rights Act again, cripple it to the point that it's really just worthless. And so they didn't do that. And so that's how twisted things are in this country when it comes to our democracy, that not doing something that they should not be doing in the first place is considered a victory. And so Chief Justice Roberts sided with the Black community in this case. And he, I think because that, I just have to tell you, the U.S. Supreme Court has taken a hit in many ways. Its rating among the people, its trust among the people has dropped considerably since these Donald Trump appointees have gained access to the court and undermined the rights of women and other people. And so I think Chief Justice Roberts understood that it's his legacy at stake now. It's just not a single case. He's going to be known for a court that is seen to be one that is not for justice, is just for political expediency.
Many of our viewers around the world might not be all too familiar with the term gerrymandering. It's not illegal per se, but can you explain how Alabama's gerrymandering violated the Voting Rights Act?
Well, if you think about the word gerrymandering, it was named after a politician from hundreds of years ago with the last name of Jerry. And the idea was that the districts that were drawn, even back then, were so contorted and confused, they looked like salamanders. And that's why they came up with the phrase gerrymander. And so when they gerrymander these particular districts, they do it in a way in which they drop off certain communities, they curve around another one, they go behind and they scoop up certain communities in order to make a voting bloc that's going to have political power. And so what they do with Black communities and other communities of color is that they'll scoop around, they'll go around, they'll gerrymander around those particular communities, and they would create these contorted voting districts in order to maintain political power, undermine the political power of people of color, in particular African Americans. And this has been going on since the 1800s, when the Black vote became so powerful. And so the idea that gerrymandering by itself politically is not against the law. Gerrymandering in order to undermine the political and constitutional rights of particular groups of color, that is against the law.
That was constitutional law professor Gloria J. Brown-Marshall from John Jay College in New York. Thank you so much for all of this.
Thank you.